Welcome. Today we're speaking with Tony Kofkin, who is the managing partner and founder of Kofkin Bond & Co. Tony is speaking to us from Melbourne. Tony, welcome.
Thank you, James. Nice to chat to you, and thank you for staying up so late to talk.
Tony, the purpose of today's conversation is really aimed at those Australians who are here in the US who may be considering moving back to Australia, either sheltering in place for the winter in Australia or perhaps pulling up stumps and moving back to Australia permanently. There are some challenges, obviously, in moving back to Australia from a financial advisory perspective, what to do with your assets in the US. Perhaps, Tony, to start off, you could talk a little bit about some of the experience of your clients moving back to Australia and some of the challenges that they've faced.
Yeah, absolutely. And I mean, it obviously varies on how long they've actually been in the States and what they're doing and whether they've accumulated assets in the States. So their stints were basically anywhere between 3 to 5 years over in the US. So they were happy to rent in the US when they were working there. They were happy to have their families over there. They did have things like some 401k plans and things like that, but their planning coming back was far simpler than somebody who went to the US to work on a contract or at a major organization for 3 years, ends up falling in love, and 20 years later wants to uproot and bring the family back, but they've got a partner who is American, was born American. They've got kids now that were born in the US. So for them, uprooting and coming back is far different from the young family that have been there for a few years and enjoyed to see change, made some good money, and now have come back to Australia to work. So there are very different circumstances there. And if we're going to touch on those, a lot of the circumstances come about what if they've amalgamated, amalgamate some US assets or quite substantial US assets. What decisions should they be making prior to leaving the US? Who should they be talking to prior to leaving the US? And then what decisions should they make with those US assets when they're back in Australia? And there's a whole lot of, as we were discussing earlier, question marks. There's no one answer to that. It depends on their circumstances and what they are deciding to do when they do come back to Australia. Are they going to give up their green card or their citizenship? So investment decisions can vary based on whether they're going to give up their US citizenship or not. And this is why when we say seek advice, there's nothing that's going to come out of today where someone's saying, there's the answer, I don't need advice. Whether it's us or whether it's someone else, certainly seek advice prior to getting up and making those decisions.
Some Australians who are thinking of, pulling up stumps, so to speak, and moving back to Australia, they have a lot of financial assets in the US. Some of them, as you mentioned, it depends on whether you've been here on an E3 and you don't have any financial footprint in the US, so to speak, as opposed to a long-term green card holder. Can you speak a little bit from the Australian side of things, of your clients in Australia, some of their decision process about what they do with their US assets when they do return to Australia?
It's a great question, actually. So once again, there's probably several different scenarios, but if we look at the normal scenario that happens, they've amalgamated, some good assets. There could be bank accounts, it could be a property in the US, maybe even a couple of properties. It could be quite a substantial amount of money in mutual funds or in other shares in the US, etc. They've come back to Australia. They've decided that they've sought advice on maybe even converting some of those assets to cash with a view to bringing it back to Australia to come back and live in Australia. They haven't got a property in Australia. They want to use, $1 million of that to buy a house in Australia. The kids are now going into secondary school, and everything is a thought process of where they want to move. The next part is then they come and see a financial planner and they say, well, I've got this $1 million left over. I want to invest it because I've just missed out on 20 years of superannuation savings because I've been living in the US. But what's the best thing that I can do for it? And they get their normal financial planning done. And one of the biggest mistakes that they can actually make then is that if they still have their US citizenship, or as you said, substantial long-term green card holder, if they still actually have that, of course, they have to lodge their tax returns both in the US and Australia every year. investing for a US citizen or substantial green card holder, investing in mutual funds, well, from the controller trust or the PIFIC taxation laws, in mutual funds here or managed funds or even exchange traded funds or even direct equities, with the exception, everything with the exception of an investment property and cash is actually going to virtually be double taxed. So as an example of that, you might have $100,000, let's say for round numbers, in an ETF, and that has now risen. It's been a decent year, and it's now worth 115,000. But there's been no realised capital gain in that whatsoever. But the gain here under the PIFIC laws, the gain here is actually being classed as realised capital gain in the US for their tax returns. So although they haven't actually realised that, they actually have to put that gain down in the US tax returns. So basically, they are getting taxed on something they haven't realised here. So from that scenario, if they had assets in the US and they were to then redeem those assets and bring it to Australia and then make the same investments, say, into mutual funds here in Australia, that would be one of the worst decisions they could actually make. So if they wanted to keep those as investments, it's actually more, from a taxation perspective, far more beneficial for them to keep them in mutual funds or investments in the US for as long as they are that citizenship. That's not necessarily the advice I would get from an advisor who doesn't understand the cross rules, but it's something that's vitally important, because if they still got that 15% return, let's take currency out of the equation here. So let's not worry about fluctuations in currency, but that 15% return in their mutual fund in the US without any realised capital gains is far more beneficial than the 15% return on the mutual fund here in Australia, which is going to get taxed as if that has been realised anyway. So from a long-term investment perspective, it is better for them in this scenario to actually keep their investments in the US. If they're keeping their citizenship or green card, or if their significant other was born in the US and is a US citizen, is not necessarily an Australian citizen as of yet, but has come over as a spouse on a spousal visa to start with. So they're considerations, major considerations to make of, do you keep the investments in the US? And this is what we always say. This is the advice you have to get before pulling up stumps and coming over here and making those decisions.
Another factor in this, of course, is the HART Act, which was brought in under the Bush administration, which essentially is a taxation on unrealized gains in your global assets if you relinquish your green card or if you're a US citizen and relinquish your citizenship. But I do know of a situation where a couple had moved to America. We were discussing this earlier. They bought a house on the beach for, I think it was $125,000 back in the 80s. Which was a lot of money then for a house. It appreciated to several $1 million when they're in the United States, and when they relinquished their green cards without getting advice, they actually had to pay the tax on the unrealized gain, which was some $2 million, and they ended up with a bill for $800,000.
And I think the key to it is, James, that any decision you make when moving back, even if that decision is to move back to Australia, any decision you make has consequences. But as long as you're aware of what those, and not all consequences have to be bad, but as long as you're fully aware of what those consequences are before you make the decision, because you can't go and reverse it and say, oh, I didn't realize that, I've made a mistake, let's just reverse it. It's not going to happen. So, the Australian Tax Office or the IRS are not going to say, oh, okay, we didn't realize that you didn't want to actually realize that gain. They're just going to say, here's your tax bill, pay it. So, and that scenario of the couple you were just speaking about, they've got an $800,000 tax bill, but they actually haven't realised the gain. So they've got to stump up for $800,000 now to pay a tax bill.
Tony, there's also the issue that perhaps some people haven't considered, and that is the challenge of re-establishing residency in Australia. For example, if you've been a resident in the United States and you move back to Australia, you don't automatically get residency and access to services, say, for example, Medicare.
If you are re-establishing back in Australia, that's true. So a lot of the benefits that we take for granted here, because we've always had, when you do come back, you don't automatically get, and especially if you're coming back, say, with children who are, US citizens who were born in the US, they're not automatically going to be getting Medicare, which is our universal health care, of course. These are the things that can take up to 6 months to re-establish, and once again, it depends on the people that you're using to actually have all this done. Our philosophy is quite simple. These are all the boxes that need to be ticked before you even consider coming back. So if you start establishing that process before you come back to Australia, that process can go from a 6 to 12 month process down to a 2 to 3 month process as well. So as you said, it's not something that's going to be automatically granted because you were born in Australia and an Australian citizen, especially as you said, if you're actually bringing family back, because you're now dual citizens as well.
And of course, there's a whole issue of unemployment insurance, because one of the deciding reasons why someone's repatriating to Australia is that they've lost their job here in the US. They can't get another one. They have to go back to Australia, but they get back to Australia and of course they can't find work immediately. There's no government assistance for them because they're not Australian residents.
Yeah, absolutely. So if you are, 25 years old and that's happened, you come back to Australia, maybe you can move back in with mum and dad, but you don't want to be 50 years old and have to move back in with mum and dad because you can't afford. So it's what you're doing. But that's another thing too. You're going to come over here. There can be up to an 18-month, depending on, once again, your status, but it can be up to an 18-month wait before you'd even qualify for any form of social security.
Tony, you mentioned earlier about the situation where a returning Australian may keep some of their investments here in the United States, whether it be property or financial assets. This brings up the issue of estate planning because, again, with previous discussions we've had, there's a whole issue of having both an Australian and a US will to deal with the assets that you have in both jurisdictions. Can you speak a little bit to that as well?
Yeah, absolutely. That's a great question, James, and probably one of the aspects a lot of people forget about. But if you've still got assets in the US and you've got assets here in Australia, they're two completely different jurisdictions that have two completely different sets of laws in the event of death. Of course, in the US, and it can vary from state to state, you've got estate taxes. And of course, in Australia, a lot of assets, if they're not realised, are tax-free. There's no death duties on that basis. But in saying that, if you do hold assets in the US and hold assets here in Australia, you will need to have estate planning done for your US assets, for the distribution of your US assets. And then you'll also have to have your estate planning done here in Australia as well. In saying that, I'm not a lawyer, so I'm not giving legal advice here. We do work with some very good lawyers in the US for estate planning, as we do here in Australia as well. But understanding the process is that if you were to pass away, now we don't plan, none of us plan on that happening until, we're 100 years old, but it's going to happen one day. What is the most tax effective way, once again, of getting those assets down to your family in the best way possible? One of the biggest mistakes a returning Australian can make here in their estate planning is we will always, as financial planners, we will always recommend that in the event of your death here in Australia, that you set up what's known as a testamentary trust as forms part of your will. And that is for protective mechanisms, it's also for great tax minimisation strategies, etc. And it's only activated in the event of death. So there's no controller trust issues. But the moment it's activated, it can actually start creating controller trust issues because it is actually a trust that you're in control of that now holds all these assets. So if you're actually now in charge or the trustee of a testamentary trust because your spouse has just passed away and your children are also citizens who are beneficiaries of that trust as well, it's classed as a controller trust, bang, you're getting done under the PIFIC laws straight away from that. So sometimes here in Australia for returning citizens, in respect of the wills here, it's not in their best interest to actually have a testamentary trust set up. Otherwise, you are going to get hit with those controller trust issues in the events of death. And that can be simple things like, for example, turning a non-capital gains tax asset like your principal place of residence, automatically when it goes into a trust, it becomes a capital gains tax asset. So what we're saying is it's not straightforward as what it would have been if you're just an Australian citizen or a US citizen. You should get your US, especially if you're going to keep assets in the US, which, as I said, if you're keeping your citizenship, probably that would be something that would be recommended. You do keep a lot of assets in the US. You should ensure that your estate planning is set up prior to departing the US. And then when you're here in Australia, make sure you're speaking to an estate planning solicitor, whether it's for your financial planner or accountant, who once again understands the consequences of still holding a US citizenship in respect to getting your estate planning set up here as well.
So perhaps to recap that, really we're looking at four professional folks that you need to have in your corner. You need your financial planner and your tax accountant in the US, and your financial planner and your tax accountant in Australia, who all can talk to each other, who all understand each other's, or to a degree, each other's challenges or where the crossover is, so that this can smoothly transition you, so one person doesn't make a decision in the US that impacts your Australian tax and vice versa. Would that be fair in saying that?
That is put perfectly. To add one other thing to it, though, is make sure that none of those have conflicts of interest.
Tony, can you also talk to an additional complexity which we haven't spoken about, and that is the rules around Australia and the US that prohibit financial advisors, etc., talking to clients when they're not in their jurisdiction?
Yeah, it's a very sticky one because we all like to provide advice, and the client has actually come to you for advice. And sometimes from that, especially if you know what the answer is, sometimes the hardest thing to do is say, "I'm not allowed to answer that," or "I can't answer that because of the law. You know, legally, I can't actually answer that." But it's really quite simple. That is that if you're speaking to your US advisor, you are meant to be domiciled in the country when actually providing that advice. So that's the US advisor under SEC laws, and under ASIC regulations here in Australia, it's exactly the same. So we talk clients who are looking at coming over here. We talk in general terms, but we can't give them advice or do a financial plan, what's commonly called a financial plan here, but legally it's called a statement of advice. We can't produce that for the client whilst they're actually in the US. So we might say the first thing you need to do is go and speak to X, Y, and Z accounting firm to get that sorted out first. You then need to get this sorted out first. Speak to your financial planner in the States. I'm happy to have a chat to them, but I can't be giving you advice. And it's the same with that planner. They can't be giving advice over here as well. But also too that you've got assets in the States, they're assets that are actually domiciled in the States. I can't legally be actually giving you advice on those assets. I can only actually legally give advice on assets that you have domiciled here in Australia.
Tony, what is the solution? So we have to have financial advisors in the US and Australia who can talk to each other, but depending on where the client is, whether or not they can speak to the client directly.
So, yeah, absolutely. So that's 100% correct. The great thing about the online world every day nowadays, it's not as if they can't, log into their Charles Schwab account or log into their Amtrade trade accounts, etc. So, and see what's happening and how things are going as well.
It's complicated. That's the big
It
thing
is
about
very
this.
complicated, and that's sometimes one of the biggest frustrations is the client likes you, the client trusts your advice and will actually implement the advice you give. And sometimes where they're saying, I can't actually legally, I can't legally, my hands are tied, I can't do that. So it is an absolute can of worms. But as you said, James, all advisors should always be talking with each other at all times.
Tony, I think we might wrap it up there. I want to thank you for your time this afternoon. It's been great speaking with you, great catching up. It's been a year or so, I think, since we spoke last in person, and hopefully Melbourne will be a lot more livable in the not too distant future.
I'm fairly confident it will be. And James, it's always a pleasure to chat with you. So it's thank you very much for the invite. Thanks. Good night or good morning to you.
Good afternoon to you and good night to me.
Yes. Thanks, James.